Hello, everyone. Welcome and thank you for joining us in today's Legitclass. I hope everyone is doing well and keeping safe. My name is Chahat and I'm the moderator for the session, and I'm honored to have Mr. Ansh Singh Luthra as our esteemed speaker today. Ansh Singh Luthra is an independent counsel practicing at the High Court of Delhi. After graduating from National Law Institute, University Bhopal, he proceeded to pursue an LLM from University of Cambridge, UK on a full scholarship. He was also subsequently awarded the Pegasus Scholarship that enabled him to work in London with top barrister firms such as Garden Court Chambers and Furnival Chambers. Mr. Luthra has a specialization in IP laws and has worked extensively on licensing issues. Mr. Luthra has a keen interest in writing. He writes about practical litigation and litigation strategy in his monthly column titled Inside the Courtroom, Lawyers Update magazine. He also raises legal issues of larger public and national interest at different public fora. So today we'll be discussing COVID-19 vaccines, intellectual property, compulsory licensing, voluntary licensing, and other related issues. This Legitclass has been organized by Legitquest, which is an artificial intelligence-based legal research product. It is a state-of-the-art legal research platform for conducting legal research and is very well known for the introduction of the world's only one-click insight system called the iDraft Case Analytics. In short, the iDraft feature, powered by artificial intelligence, takes out the issues, facts, arguments, reasoning, and decision of a case. Legitquest has recently also started with Legit I, which has the latest news, interviews, and columns, and serves the stakeholders of judiciary. So before we start, let me brief you all that today's session will be for 45 minutes, followed by Q&A. I would humbly request all our participants to please be on mute and without video throughout the call. If you have any questions to us, to the speaker, please type them into the chat window and we'll address them during the Q&A. So I think we seem to be all set. I will now hand it over to Mr. Luthra now. Over to you, Mr. Luthra.
Thank you so much, Chahat, and a big thank you to the entire team of Legitquest for doing such amazing work in these trying times. We can only imagine how difficult it must be to organize such webinars and in these dire situations. So big thank you to Legitquest for having me, and big thank you to everyone who joined in today. The purpose of today's discussion or webinar is to understand the legal issues with respect to COVID-19 vaccine production, the interrelated IP issues, compulsory licensing, voluntary licensing, to understand whether we can find a solution to this pandemic and whether we can find a solution to increase production of vaccines so that everyone can have access to them, so that everyone can get them, and we can come ahead of this pandemic. The only way we'll be able to fight this pandemic is if we get vaccines in the arms of our citizens. And this virus is not going anywhere till we do so. And we must realize that nobody is safe till everybody is safe. And not just at a national level, we need immunity at a global level. This is a global problem. And if we get immunity, certain nations get immunity, herd immunity in their particular territory, and the others don't. For example, if rich nations get it and developing nations like us take more time to get to herd immunity, mutations will keep occurring, and this new mutated variants will not be, the vaccines which the rich nations have got will not be able to fight against the mutated variants and will not be as efficacious as they are towards the current variants. Hence, it is a global problem, and all of us are in this together, and we must have a collective approach, collaborative approach to this problem. Now, we must understand that the virus does not discriminate at all. It is not bothered about whether you are an Indian, whether you are a foreign national, whether you are from A party, B party, whatever your sex is. And hence it is a truly global problem, and we are all in the same boat. To understand the vaccination issue and understanding the production, supply, and the related IP issues, we must first see why patents are granted. So a patent essentially is a reward to the inventor for his invention, for disclosing his invention. He gets a monopoly right of 20 years wherein nobody else can market and develop his invention unless he gives a license to somebody to do so. And every patent is not an exclusive monopoly. It's not like there are no restrictions. In the case of India, Section 45 and 47 of the Indian Patents Act 1970 talk about certain restrictions with respect to patents. And a patent is not granted for every invention. It is only granted if the triple test of novelty, inventive step, and industrial application is met out. So if any one of these conditions is not met out, a patent will be rejected and not be granted. Before we go towards more IP and get deep into the issue of the COVID-19 vaccines, I would like to share a slide with you and compare our current situation with what happened in 1980 during the Spanish flu epidemic. Just a second. So, I hope this is visible to everybody.
Yes, Mr. Luthra, we can see your screen.
All right.
Yes, this is fine.
Okay, so in 1918, a lot of us would know that the Spanish flu, which was an H1N1 virus, hit the world very hard. At the time, the world population was about 150 crores, and about 50 crores, so 1/3 of the world got infected. It was again airborne, and like COVID is. And how it got its name was because Spanish media at the time was less restricted. It had more freedom to report than other nations. King Alfonso XIII was infected by this. He was a Spanish king and he was infected by this virus, and he had it very hard. The virus really took a toll on his health, and that's how the name Spanish flu came into being, because the Spanish king had got it and got infected. So the Spanish flu lasted for about 2 years, from February 1918 till April 1920. Like I said, it was an influenza virus like COVID is. 1/3 of the world got infected, and it also came in waves like COVID has today. So it came in 3 big waves and one small wave. And similar to COVID, we've had the Spanish flu had similar responses. Quarantine, social distancing became the norm of the day. There was a ban on mass gatherings for about 2 years. Not more than 10 people were allowed to gather together for festivals, etc., or any other social gathering. Unlike today, there was not enough good quality vaccines available. There were only antibacterial vaccines, not antiviral vaccines. And they did not prevent the onset of the disease, but they did prevent second or subsequent infection. So like today's vaccines have an efficacy of 80 or 90%, depending on which one you get, to prevent the onset of the disease or prevent the infection in the first place. The old ones did not have this capacity. And we only had basic drugs like aspirin and Epsom salts to treat the patients with. I'll share some photographs so that you'll understand how close it was to COVID. So this is a makeshift hospital in Spain. This is how 2 women are trying to wear some makeshift PPE kits and talking on the street. This is another one. Then one on the right side is a Bell ad, which says, when in quarantine, people who are in quarantine are not isolated if they have a Bell telephone. So this was the kind of marketing, etc., that was happening in the day back in Spain. This is a public notice from 1918, which says that all public gatherings consisting of 10 or more are prohibited. And on the left is a woman with a old primitive kind of an oxygen concentrator. Like I said, the Spanish flu was highly devastating. 50 crore got infected, about 5 to 10 crore lost their lives, which is a big number considering that's about 7 or 8% of the world population back then. But the Spanish flu ended in 2 years because of quarantine, ban on mass gatherings, and masking. So one more similarity of the Spanish flu and COVID is that they have a similar R0 or R factor. So what this R0 or R factor tells us is that if there is one person who is infected, the R0 signifies the number of more people that infected person has the potential to infect. So for example, if the R0 number is 2, so each infected person will have the potential to infect 2 more persons. And the Spanish flu and COVID-19 have similar R0 or R factor numbers, which varies between 2 and 3. Again, the Spanish flu was a global pandemic. Global immunity was required. Mutations used to happen. And similarly, COVID has the same traits. The silver lining today is that we have better vaccines, we have better medical infrastructure and better understanding of the disease. But unfortunately, over the last year and a half since COVID has set in, we are still not able to get ahead of the disease. And now we'll try and figure out through the next slide why that is and how through legal solutions, through compulsory licensing, through voluntary licensing, we have the capacity to beat the virus. I'll just share another slide with you. So compulsory licensing basically is covered under Chapter 16 of the Indian Patents Act 1970, though for our purposes today, we'll only focus on Section 92. There are other provisions under that chapter which deal with compulsory licensing in different situations. For example, 84 deals with compulsory licensing for not working of a patent, and we have granted one compulsory license in 2011 for not working of a patent for the drug called Nexavar, which was appealed all the way to the Honorable Supreme Court, and the compulsory license was held to be valid. But Section 92 is a specific section which deals with compulsory licenses in cases of national emergency or situations of urgency. So compulsory licensing, like I said, is a provision under the trade-related aspects of intellectual property. Under certain conditions of national emergency, it is a tool in the hands of the government through which it can ensure the right to health of its citizens. So what a compulsory license is, when a patent is granted and in certain criteria are met, the government can, after a notification in the official gazette, say that due to these emergent situation, due to national emergency or urgency, we hereby suspend your patent rights, and applicants who come to the controller of drugs will be granted the license to manufacture that patented drug or vaccine. So patents can be both for drugs as well as vaccines. And in this, we must realize that the right or the rightful amount of money or license fee or royalty of big pharma is not taken away. It is not that a compulsory license, his rightful work and his toil is snatched away. He will also, the patent holder, big pharma, will also get a license fee or a royalty by the applicant who gets the license from the controller of drugs. So what compulsory license basically does is it immediately lowers the price of drugs because they are manufactured in a much bigger, much more quantity. And it also makes them more accessible because of increase in supply. And it makes them, and it also gives a profit to the patent holder. But the difference here is that under a monopoly, a patent holder may be able to make super profits because nobody else is allowed to make his vaccine or drug. But under a compulsory license, he will only get a normal profit. And the license fee is also decided by the controller of drugs. So this is the procedure under Section 92. I've just got this down into 4 points so that it's easier to understand. So the first aspect, like I said, is declaration by notification in the official gazette, post which the controller of drugs may grant these license to any interested person. So interested person would mean someone who applies and someone who has the capacity to manufacture. Then the terms are decided by the controller, and the controller will ensure that the patented drug or patented vaccine is available at a low price, and the patent holder also gets a reasonable advantage in the form of a license fee or a royalty. Like I said, they'll not be able to make super profits, but normal profit. This is a photograph which it's very apt in the Indian context, where now we are being asked to register online to get our doses, though we must get them as soon as possible. So compulsory licensing is one way to increase our production and lower our costs. I'll just stop sharing and I'll continue. So again, there's one more important aspect about compulsory licensing, that it is not as if this is it's granted for eternity. What happens is, generally compulsory licenses are granted only to tide over emergent or emergency situations or national health emergency situations. So in that case, a compulsory license might be granted only for, say, 6 months or 10 months or a year, just enough time so that we could tide over that situation, create enough production, bolster up our supplies and storage, and then the patent holder will again be allowed to manufacture his patented invention. This is called a sunset clause. So that 6 month or 10 year or 10 month or 1 year period is called a sunset clause. So, like I said, this can be done in case of essential drugs as well as vaccines. So remdesivir will be a great candidate, etc. These drugs which are required now, tocilizumab, ivermectin, favipiravir, etc. So in 2011, like I mentioned before, a compulsory license has been granted in India for a drug called Nexavar. And it was granted to a company called Natco Pharma. And just to tell you in real world terms what kind of effect it had, this was obviously different. It was granted under Section 84 for not working of the patent. That means the drug was not available in the requisite quantities that it was required. But just to understand what kind of a difference it would make if a compulsory license is granted. So the patented drug was available for about 2 lakh rupees. It was a liver cancer drug. So the monthly dose costed 2 lakh rupees per month, which was obviously very expensive because it was a patented drug and there was a monopoly. After the compulsory license was granted, the generic version of the same drug was now available for 8,000 rupees. So if you look at the magnitude in which the price fell and availability went up, these licenses do really help ramp up production and make these vaccines and drugs much, much more affordable. This was appealed, like I said, this was appealed all the way to the Honorable Supreme Court, and the Supreme Court upheld the compulsory license. Have other countries done it? Yes, of course, other countries have done it. A big example is the AIDS epidemic in 2001, wherein countries like Brazil, Ghana, Indonesia, Ecuador, etc. had done it. Zimbabwe did it. And in fact, Zimbabwe and Ghana went ahead. They just didn't compulsory license one particular drug. They had an all-encompassing compulsory license wherein any drug made to treat AIDS was automatically compulsorily licensed. Has this been done in the present context? Yes, it has been done. So as recently as 24th of March 2020, Israel did it for a drug called ritonavir, which is an HIV drug. Initially, they thought that this will help in COVID treatment, and hence they passed a compulsory license for that drug. Canada made amendments in its own patent act, which would allow compulsory licenses to be granted easily. And interestingly, the amendment allowed for a license fee to be negotiated at a much later stage. So right now, a compulsory license would be granted, and at a later stage, the Canadian authorities would decide the license fee. So in the Indian context, like I said, it's been done before. In other countries, it's been done before. In respect of COVID, it has been done before. But unfortunately, we did not pay heed to this over the last 1.5 years. And the Honorable Supreme Court took suo motu cognizance. And on the 30th of April, about 2 weeks ago, they suggested to the government to look into provisions of Section 92 of the Indian Patents Act, look into compulsory licensing, look into Section 100, which is import, etc., for government use, and also look at voluntary licensing. Further, the Supreme Court asked the government of India to tell it the supply schedules, the projected demand of these vaccines, and how it will meet this demand. Post which, it also said that the dual structure strategy of letting states acquire 50% and the center get 50% of the vaccine must also be looked into, because it will not stand the test of Article 14 and Article 21 being right to equality and right to life. Right to health is obviously covered under Article 21. But we must understand that this is a policy matter and it is a policy decision for the government to take. And hence the Honorable Supreme Court is only having a dialogical role. It wants to have a dialogue with the government to bolster up supplies and look at possible solutions to ramp up production of these vaccines. In fact, another interesting aspect that we could consider, specifically in the case of remdesivir, is that since Bangladesh falls in the LDC category, least developed country category, this is a special category at the WTO. So TRIPS provisions, these provisions of guaranteeing patent rights do not apply to such countries which are poor countries such as Bangladesh. Now, what that being in this category enables Bangladesh to make generic versions of patented drugs. So Bangladesh, in fact, makes a generic version of remdesivir, which is in shortage in our country and is become so popular over the media because less availability. So India can, in fact, even look at importing these generic versions, which will be much cheaper from countries like Bangladesh. Interestingly, the affidavit of the central government before the Honorable Supreme Court stated that we will now look into these provisions, and we will also talk about, we are also in talks with other companies, PSUs, for voluntarily licensing Covaxin. So what the difference between a voluntary license and a compulsory license is, when a compulsory license is by government order, when the controller of drugs through a notification grants it to applicants. A voluntary license is when the patent holder himself gives a license to somebody else to manufacture his invention. So we must understand that now India is not just the pharmacy of the world. We are not just the vaccine factory of the world. Some of you may be surprised to know that we make more than 800 crore vaccines every year, which is about 62% of the world vaccine supply. Obviously not COVID vaccines, but vaccines for other diseases. And we make a lot of generic drugs. We are popular for that. So we are not just the pharmacy or the vaccine factory of the world, because Covaxin is made with the help of government institutions, being NIV Pune and ICMR, obviously with collaboration with Bharat Biotech. And now, because of that, the people of India, the government of India, is actually a patent owner in this Covaxin. What that does is, and why that is a big positive, is that we can ourselves voluntarily license the license for Covaxin to anybody who has the capacity to produce and who has the willingness to produce. Whether it is a state entity or a private player, that does not matter. And again, these licenses and royalty, etc., these negotiations can happen between the government, Bharat Biotech, and this third applicant, whoever wants the voluntary license. So voluntary licensing is a better, faster, quicker approach than compulsory licensing. And it is a very low-hanging fruit since we are the owners of the intellectual property. I must also share with you why some people are against compulsory licensing and why it is a very high threshold to cross, though there are negotiations taking place at the World Trade Organization as we speak. So some people say that, before that, I'll tell you what is happening at the WTO. So India and South Africa had in fact moved a proposal to the WTO to waive certain TRIPS provisions which would have allowed us to manufacture generic drugs, which would allow us to manufacture patented drugs, basically generic version of those patented drugs and these COVID vaccines during the pandemic period. So in our proposal, we had said that to waive these TRIPS provision just for the pandemic period, so that developing nations can have access to these patents and these formulas, so that generic versions of these patented vaccines and drugs can be made available and lives can be saved. Now, this proposal was sent in October 2020. Unfortunately, nothing happened on this proposal as far back as mid-April 2020. In middle of April, Catherine Tai, who is the US trade representative at the White House, because of international pressure, went and spoke to the CEOs of Pfizer and Moderna about India and South Africa's proposal. What had happened is 120 nations had backed our proposal. Senators such as Bernie Sanders, Elizabeth Warren, Chris Murphy, Tammy Baldwin also wrote to President Biden to back our proposal, ours and South Africa's proposal for this TRIPS waiver. And hence there was a lot of diplomatic and international diplomatic pressure created at the WTO, and therefore Catherine Tai went and spoke to these two big pharma companies about our proposal. Post these letters, post our proposal, post speaking to Pfizer and Moderna, US took a very positive U-turn and stated that we will back India and South Africa's proposal. The only problem was that they wanted to back a very narrow portion of our proposal. Nonetheless, big positive for us. Post which, again, the EU was forced, and EU was also saying, okay, now we'll talk. And now in June, the talks will be held regarding this waiver. What this waiver has the potential to increase production and supply, because compulsory licensing will not have to resort to compulsory licensing, because these patents will be suspended for the pandemic period. And during this period, any country like India, Bangladesh, any developing country will be allowed to make these vaccines and drugs without having to enforce these patents. And this will again drive affordability, increase production, and make these vaccines more accessible. Unfortunately, about 3 days ago, the chief of the WTO, Ngozi Ikanjo-Iweala, said that though these discussions are going on and these written discussions are going on, and there'll be a session in June now at Geneva. However, the WTO said that they are of the opinion that a pragmatic solution to our proposal can only happen sometime in December. So we were earlier hoping, India was hoping that we would get a pragmatic solution or some positive inclination by June or July, so that manufacturing could be ramped up immediately. But unfortunately, now we are only seeing a longer timeline, and only something positive might come on this front by December. Hence, it's even more imperative today to ramp up our own supplies, make our own vaccine, Covaxin, which is a Bharat Ka vaccine, so that our vaccine is more accessible. It can be given to anybody who wants it. It is available at every nook and corner, and people's lives can be saved. Coming back to why certain people say that a patent waiver might not be the best thing, and it might not work in the present circumstances. So for that, there's an argument that even if you waive the patent, the companies may not share their technology, share their know-how. A lot of us might be aware that Moderna, for example, has said that they are not going to enforce their patents for this pandemic period. However, still nobody is manufacturing Moderna's vaccine. That is because after patent waiver is only the first step. After patent waiver, technology sharing, technology transfer also has to take place. So, for example, for vaccines which work on the mRNA technology, proper technology transfer, setting up of factories, vaccine manufacturing production lines, SOPs, everything has to take place. So just the patent waiver will not be enough. This is one big hindrance to just the patent waiver, and hence tech transfer must happen immediately after that, so that these vaccines can be manufactured in every country. For this, the WHO took an initiative and made a tech transfer portal, but unfortunately, these big pharma companies have not come forward and shared their technology on that portal. So that portal, basically the aim of the portal is to share technology for everybody to access it, so that once patent waiver happens, every country will be enabled with the help of that shared technology to manufacture these vaccines in their own jurisdiction. Similarly, for Covaxin, though Covaxin is developed and the technology which Covaxin uses is a more tried and tested technology, it is based on an inactivated virus. So basically the vaccine itself contains the entire virus, which is in an inactivated form. So you can't get COVID from the virus when you can't get COVID from the injection, but your antibodies develop. The other technology, the mRNA technology that I was talking about, which AstraZeneca uses, for example, only has the spike protein. So the spike protein is the protein through which the virus attaches to your other cells. And hence immunity is developed in a different way through that vaccine. So in case of Covaxin also, there are skeptics who say that, okay, today license is granted. And again, a big positive is that ICMR, as day before yesterday, stated that they are willing to share their know-how and grant licenses to anybody who wants it. But skeptics state that even if licenses are granted, it will take at least 3 to 6 months for a biosafety level 3 facility to be made available, which is required to manufacture these vaccines. Now, though that is the case, the Bombay High Court, in fact, has about 4 days ago allowed BioVet, which is a Bharat Biotech company, to take over an existing factory, which is a biosafety level 3 factory owned by Intravet, which is a Merck company. This factory was lying idle for many years, and now on war footing, licenses are being given to BioVet to manufacture Covaxin from this factory. So this is one good way where the courts have intervened and have allowed an idle factory to be taken up to produce this biosafety level 3 Covaxin. Similarly, existing supply, like I mentioned, we are the vaccine factory of the world, and our installed capacity is about 820 crore vaccines a year. So existing factories which are biosafety level 3 can immediately be repurposed to manufacture Covaxin, which will not only increase production immediately and will not need this 3 to 6 month period where a new factory is set up. Our original supply can be diverted, original factories can be repurposed, and Covaxin production can be enhanced immediately, driving up supply, making it more affordable, and again, granting some royalty, some license fee to the owner, which is ICMR and Bharat Biotech. So these two solutions together, compulsory licensing, which is a slightly less popular approach, but right now, again, we must not be concerned about popularity because people's lives are at stake and we are literally losing people by the minute. And voluntary licensing, which is a very low-hanging fruit, wherein the government of India is the owner of the patent, people of India are the owner of the patent, share their own technology, share their license with other people who are capable to manufacture these vaccines, would ramp up production, make these vaccines more affordable, and would help us tide over this pandemic. The only way we are coming ahead of this virus is if enough people get inoculated. This is a global problem, not an Indian problem, and hence everybody in the world must get inoculated, for which the world must come together, have a collective, collaborative, and concerted approach towards vaccine manufacturing, production, supply, and affordability. So big pharma must show us their humanitarian face, voluntarily give out these licenses, not oppose the TRIPS waiver. All these big countries must come together, share their technology, so that developing nations like us can enhance our production and inoculate our own people. So like I said in the beginning, I would like to end with the same sentence that I shared in the beginning. Nobody is safe till everybody is safe. And hence, all of us must get this vaccine. It is our right under the Constitution of India. Thank you again, Legitclass, for having me. I'm very happy to take questions after this.
Thank you so much, Mr. Luthra. It was quite an insightful session. Now, moving to the Q&A session, we have received a few questions, which I'll take one by one. If you feel you have answered any question, you can please let me know, so I'll go to the other one.
Perfect.
So the first question is, at this point, would a vaccine patent waiver will ramp up the scale and speed of vaccine rollout?
So a patent waiver, like I said earlier, a patent waiver is the first step, but it is the right step. After a patent waiver, there also has to be technology transfer. So a patent waiver will definitely be the first step in increasing vaccine production, but post which technology transfer has to take place. Like I mentioned earlier, the WHO has made a portal for this, but unfortunately, Big Pharma has not come forward and shared their technology. But in the case of India, since I think because of the international dynamics, the pending proposal at WTO, we have still not resorted to Section 92 in our own domestic case. But a patent waiver definitely, in the longer term, in 3 to 6, 8 months, can increase vaccine production, provided technology transfer also takes place simultaneously.
Okay, thank you so much. Moving on to the next one. Should the Indian government invoke Section 92 or 100 of Patents Act in view of present public health emergency, or should the Supreme Court intervene in this?
So this is not a fit case for the Supreme Court to pass directions to invoke Section 92, because this is a policy matter. So the Supreme Court very rightly has said that they want to play a dialogical role in this respect. They don't want to force the government's hand. They have, in fact, told the government that you look into Section 92, you look into Section 100, which is imports, etc., government use, look into 102, but they are not directing the government to do so. That is precisely because it is a policy issue.
All right. Mr. Luthra, the next question is, what is the usual time frame taken in completing the process of compulsory licensing?
So if everything goes, everything goes right, all the right steps are taken, and there is no faux pas, there is no hindrance, it would take between 3 and 6 months for factories to be up and running and these jabs to be produced. However, I must state that voluntary licensing is a faster way to get jabs because, like I mentioned, Covaxin is a Bharat ka vaccine, and the government of India, people of India are the owners of the intellectual property of Covaxin. We can voluntarily give out these licenses to anybody who is willing and has the capacity to manufacture. We can repurpose existing factories to manufacture Covaxin, and we can also take into account idle factories and give licenses on war footing, like the Bombay High Court has now directed clearances to be given to BioVet for manufacturing Covaxin. So they've taken up an idle factory which was earlier owned by Merck & Co, a subsidiary of Merck & Co, Ivermet, which is now being given to Bharat Biotech. So that is a faster way, but compulsory licensing must also be looked into.
All right, thank you so much.
Let me just add. So in case of voluntary licensing, the time frame that you were asking would be much shorter. It would probably be a few weeks if everything is done at war footing, maybe 4 to 5 weeks.
All right, okay. Thank you so much. The next question is, when we talk about compulsory licensing, what all does it allow?
So like I mentioned before, compulsory licensing in the present context would allow us to manufacture any drugs as well as vaccine. So, for example, drugs like remdesivir, ivermectin, favipiravir, tocilizumab, which is a arthritis injection, which has now been repurposed for COVID treatment. All of these can be compulsory licensed. Obviously, depending on whether criteria of those compulsory licensing is met, whether it is under Section 92 or Section 84. So under Section 84, for example, if a drug is not available or it is too high priced, a patent is not worked in India, a compulsory license can be granted. There's a key difference between 84 and 92. 92 is only in case of national public health emergencies or urgent situations. 84 covers other situations, and under 84, a compulsory license cannot be granted for the first 3 years of the patent. But under 92, there is no such time restriction.
Okay. Thank you so much. The next question is, should the patent laws be amended? Because in this COVID, a faster grant of patent or a waiver would be more efficient.
See, I don't personally think we need to amend the patent law because Section 92 itself is in the present patent law and it is effective enough if we utilize it. So I personally don't think we need to amend the patent law, though some countries have done amendments to their patent law, like Canada has done, wherein they've now allowed for compulsory licensing and license fee to be negotiated at a later stage. But I think our patent law is sufficient. Section 92 sufficiently deals with emergency and national health emergency situations. The only consideration today is whether the government of India should resort to Section 92 or not, or whether they want to pursue the diplomatic channel at the WTO. So that is the issue today. And the second connected issue is of voluntary licensing and how fast Covaxin voluntary licenses can be granted by the government of India to other entities. So those are the issues today, but I don't think we need an amendment in the Patent Act to deal with the present situation.
Okay, thank you. The next question is, vaccines and other medical equipments are mandatory to be registered under intellectual property rights in India. And is there any legal or penal provision for non-registration of the same?
See, right now, if you don't register your patent, there is no protection. So there is no point in even talking about non-registration today, because anyone who is going to manufacture a vaccine or a critical drug will want this monopoly and will register their patent. So non-registration, I don't think it doesn't play any role today. So registration, the vaccines, once they are manufactured, they are registered so that this monopoly can be availed by the patent holder. And that is precisely why patents are granted, so that once an invention is disclosed, some kind of reward is given to the patent holder.
Okay, thank you, Mr. Luthra. I think there's one question which you have already covered, but I'll just still put this before you. Is there any argument against lifting COVID vaccine patents?
Yes, so the argument, there are two arguments. One I mentioned in my presentation is that even if you grant a waiver, it will still take some time, and just a waiver will not be enough to make these vaccines, since technology transfer also has to ensue. So that is one argument which I agree to a certain extent. But like I said, Big Pharma must show us their humanitarian face and not just agree to patent waiver, but also agree to technology transfer, so that all of us can get these jabs and tide over this crisis. The other argument, though it will not, it's not very relevant in the current situation because it is an health emergency situation. So patents are granted after a lot of R&D, a lot of investment, and a lot of people now say that if you waive patent rights, it will deter future invention, future innovation, because people will not want to invest more in future vaccines and future drugs, etc. This is a great argument in the normal course of things, but today, in this national health emergency situation, we must not worry about whether there will be future vaccines, whether somebody will be deterred or not. Right now, our primary concern should be saving lives. And like I mentioned in my presentation, it is not like we are snatching away these intellectual property rights of Big Pharma. They are also given a license fee in the case of compulsory licensing as well as voluntary licensing. Another related aspect that I would like to share with you is that a lot of R&D money which has gone into these various vaccines is actually public money. So I agree that Big Pharma has done a great job and they've invested some of their own time, effort, and money. But a lot of it has happened through grants, through loans, which are all public money. Just to share with you, the AstraZeneca vaccine was actually made with the help of the University of Oxford in United Kingdom. And a 67 million pound grant was given to the University of Oxford by the UK government to develop this vaccine. Similarly, large orders have been placed before efficacy results have come in by rich countries such as the US. They placed an order initially, I think in the month of May 2020, before any efficacy results, clinical trial results were out, of about $1 billion. So more than 7,000 crore rupees were already committed by the United States of America. So this is all public money. And even in the Indian scenario, about 67-80 crores or 70-80 crores have been invested by ICMR and NIV Pune for conducting trials of Covaxin. So this argument that people will be deterred from future innovation and won't spend money to make future vaccine and drugs is great in the regular context, but not in today's context in an emergency where we are losing lives.
Thank you so much, Mr. Luthra. We have a few questions in the chat window. I'll just take them. One is, in the situation where NDMA is in force, can it be construed that it itself acts as a notification as required in Section 92?
No, because under 92, the notification has to be in the official gazette, and only the central government is empowered to do that.
Okay, thank you. The next question is, any views on trade secrets on COVID vaccines, mainly data developed during clinical research and other R&D?
So this is a very pertinent question, and I partly covered it where I say that technology transfer also has to happen after patent rights are waived. So a lot of times we must understand that we are in a commercial market, and Big Pharma would only want to disclose as little as it can to get the patent monopoly. So sometimes certain things which you may call trade secrets are not disclosed in patents, results of clinical trials, etc., etc. And hence that is why it is imperative that once patent waiver is granted, all technology transfer takes place, trade secrets are shared, so that developing nations and other nations can develop these vaccines. Only a patent waiver will not be enough, but I must say it is the first step, and it must be considered.
Thank you, Mr. Luthra. I think we have covered all the questions. Is there anything else that you would like to add before we wrap up the session?
Well, I would just like to repeat that it is imperative that we use provisions under the Indian Patents Act. And also, since we are the owners of intellectual property in one of these vaccines and whose efficacy is being praised world over by experts such as Dr. Fauci of Covaxin, we must grant these licenses, ramp up production immediately, get jabs in the arms of our citizens. It is also in the benefit of rich nations, developed nations, because if the world level herd immunity is not obtained, mutations will continue to take place, and the shield created by these vaccines for citizens of the developed nations will be breached by new mutations of this virus, and hence it's beneficial for the entire world, the developed world and the developing world, that herd immunity on a global scale is reached. The only way to that is vaccination, and nobody is safe till everybody is safe, and hence vaccines must be given to one and all.
Thank you so much, Mr. Luthra, for joining us for such a knowledgeable session. Thank you on behalf of Legitquest and Mr. Karan Kalia to spare your valuable time for this Legit class. It was an honor to have you here. Thank you, sir. I would also like to thank our participants. We appreciate you signing in. For recording of this Legit class, you can subscribe to Legitquest YouTube channel. We hope to see you again next time. Take care and be safe. Thank you, Mr. Luthra.
Thank you.
Thank you, Ansh. Thanks a lot. It was
a
full, insightful session. And thanks for taking out the time and speaking for us. Thank you so much.
My pleasure.